My name is Jenna Owe. I am happy to be here with you all today. I am a licensed psychologist and a school psychologist working for both psych services, and I also work within the school district. So I've been working as a psychologist for about a decade in a variety of settings, schools, private practice, hospital, community mental health. And specialize in early childhood and autism and developmental disabilities. But I am looking forward to sharing some of the information that we've gathered for you today.
And a little bit to follow up on that, thanks, Jenna, is we have worked through the summer putting together guidelines, and a lot of it's been trial and error, trying different assessment practices, what's been working best using protective equipment, remote assessment. And so after we go over some of the basic legal things, Jenna will get into some of the practices that we've been using and the approaches that we've been using. There are two options for you to ask questions. It looks like most of you figured it out. The chat box is public. So if you put something in there, other participants will be able to see it. The Q&A section is for just Jenna and I to look at. So if you have a question you prefer not everyone to see, you can go ahead and put it in the Q&A. We're going to be stopping periodically throughout the presentation to check questions and things like that. So if we don't answer it right away, just give us a second and we'll get to it when it comes to a natural breaking point. But without further delay, let's go ahead and get started. So there's been a couple of major legal things that have come out in the last several months related to COVID and assessments and services, which if you are a school psychologist or an administrator, you are probably really interested in the assessment piece of it, because we've been in this holding pattern. And if you are an administrator or a teacher or something like that, then you might also be interested with the services side of it. So there's a national class action lawsuit that came out of New York, and we're still not even sure what the total impact of this is going to be, but they were seeking and are seeking an immediate injunction for schools to reopen for students with disabilities, not necessarily all students, but students with disabilities, so that they can receive in-person instruction. They're also asking that schools provide vouchers to parents or some option for them to be able to engage in self-cure. So that means to go out and find an outside agency, a private person, doctor, medical, whatever, so that they can obtain in-person services. That seems to be one of the areas that's emerging that could be problematic for schools, or it's something that you're probably seeing, is that parents are asking for in-person services. If the student is at home, that's not a possibility. If they are not able to come to school, not able to receive in-person services, and parents are wanting outside agencies to provide those. I do know that several larger districts in California, Southern California, have been already named as part of this class action lawsuit. So it's definitely something we're probably going to see as problematic for some time. Here's some areas that it really is going to be unclear how the courts decide to rule with this in regard to the class action lawsuit, is that they're asking that schools provide independent evaluations of students with the purpose of determining compensatory education. So was there regression, and we'll get into comp ed in just a minute, and as well as to pay for compensatory damages. I have several families that I've been working with that have paid for private services during the closure, and I know they're in the process of seeking reimbursement from the school as well. And the class action lawsuit is seeking for districts to pay punitive damages. I will say, and this is just primarily from experience, we don't have a lot of data yet for this, is that the schools that seem to be having the most difficulty in this area with the compensatory services and things like that is because no services were being provided during the closure, and they've been slow to start services since the closure is over. Looks like we have a couple questions. Okay. All right. So there are a couple of court cases that have been adjudicated in California recently that are related to COVID. There's not very many. I expect we're going to be seeing more, especially as it relates to some of the class action lawsuits the class action lawsuit that I just mentioned. One of the ones that's probably most directly related to COVID or directly affected by COVID is Parent versus LAUSD. This ruling came out in August 24. I have the main issue. There were several issues. I only included the two that were COVID related. The main one is bolded here. The question is basically, did the school fail to provide FAPE to the student during a distance learning opportunity in a way that significantly affected the student's ability to access their individualized education program, their IEP? The other was the student's rights violated by the school not seeking out an adult day program? This case is unique, and so I don't know how generalizable it will be, but there's definitely a COVID-related component, is that this student was 21, so was getting ready to age out of the system, and unfortunately, the closures happened during what we would think of as their senior year. The student was not able to access a transition program. The school was not providing any services. So essentially the student aged out of school aged services. And it was kind of like, all right, what are we going to do with this student now that they're not part of the school system anymore? And so the parents were contending that the school didn't implement primarily the transition related services that the student was in the student's IEP. So the findings were that the courts determined that LAUSD had denied the student FAPE because they didn't adequately implement the transition plan. It's also important to note that services were not provided really during this time. It was definitely just school shut down and nothing was going on. Had services been provided that were appropriate during that time, the student probably would not have prevailed. The district prevailed on the transition program because the transition program had to do with the regional center, and the school is not in charge of the regional center. So that's why that finding went that way. So the order, this was another tricky part about this case, is because you can't give the student just another year of support. They can't go back into their last year of high school and sort of have a do-over. So what they found is that the school was going to have to pay for post-secondary transitioning services and coordinate with the California Department of Rehabilitation and things like that. They also wanted the district to pay for compensatory services, speech therapy, things like that. And then there was a cap on the price, which is pretty common when we're looking at ALJ decisions. The next case is Parent versus Newport Mesa Unified School District, which is a district down here in Southern California. Did the district deny student FAPE by failing to send parents prior written notices in response to the closures? This is another relatively unique case. There were a number of issues also associated with this case, but this was a student who was placed in private school. And I have seen a couple of these cases start to crop up where the student is in private school. The school district shut down. The school district that the student resides in shut down. The district if the student is not enrolled in the district is not required to provide the student that is attending a private school with a prior written notice about their school closures. The school that the student attends is required to do that. So that was part of the complaint that was included in this. I think there were 10 items. Most of it had to do going years back. So what the findings were was the student was enrolled in a private school and was not enrolled in the district. So they were not required to provide the student with a prior written notice. How I think this could potentially impact us, like I said, is that if you've got private school students that were within district boundaries, I have seen now districts are getting requests for initial assessments or reassessments and things like that because the private schools were shut down as well. The students are starting to regress. So I have seen more private school cases getting kicked back to the school districts as of recently. So I can see this potentially being another issue that crops up in your districts. Then there was Parent versus Bellflower Unified School District. So this was another transition related case. Did Bellflower Unified deny the student FAPE by failing to provide a transition program? The transition services were delayed due to COVID. Here's the issue between this case and the one that was in LAUSD is that because the district had a plan in place and said, we're going to contact these people, we're going to do this, we were not able to contract or work with this agency because they were also closed, because they had documentation that they were doing something and they were going to act on all of these things once services were resumed, not even necessarily with the school district, but once the community agencies resumed, the district was going to act on that. They had that in writing, they had documentation of that, and so the district prevailed on this issue. Another case was Parent versus San Juan Unified School District and Visions and Education Charter School. So it's a charter that's within the district. There was a child fine violation prior to school closures. This case has some to do with COVID. The problem was the parents provided assessment data and a request for a psychoed evaluation. The district Visions denied the assessment, and there wasn't necessarily good data to support why they were denying the assessment. And so what basically happened is that COVID kicked in, and the school district then, because they had delayed for so long, was not able to conduct the assessment, and they got in trouble for that. So the child find violation was potentially had occurred even prior to COVID because there wasn't a good reason to deny the assessment. And they hadn't done the things that they were supposed to do. But then once COVID kicked in, they said, oh, well, we can't assess. And we'll talk about some of the change in guidelines, but essentially we don't have a stay anymore. If an assessment needs to be done and we have data that show either for an initial or a triennial that that assessment needs to occur, we need to do it. What the courts are saying is basically, if you're not able to do it in person or the district is not able to provide those services, the district needs to find someone who can. So it's either an outside agency or the district is looking into how they can reorganize maybe staffing decisions and staff placements this academic year to help make sure that those occur. So the summary of the current case law and where we're at is it's still emerging. This is a relatively new issue. It takes a while for things to move through the courts. I think the class action lawsuit is the one that probably will have the most pervasive impact on schools, and really for us to start thinking proactively about compensatory services. Senate Bill 117, we're probably all familiar with. This was kind of our no fault time period where, because the schools were closed, we all just kind of got a pass on meeting timelines and everything else, and everything really came to sort of a standstill at this point in time. However, it doesn't waive federal requirements imposed under IDEA. And this is probably the issue that the class action suit is most directly addressing, is that some places completely shut down and no services were provided. There seems to be where the courts are going to move into, and the way things are going to happen is that compensatory services may be found to need to be provided if services were not provided during the school closures. And I know some schools are still struggling to get up and running right now, just based on the issues related to distance learning. Senate Bill 820 is where we're at now. This was September 8th, 2020. Essentially, we are having now to figure out how to implement an IEP within a distance learning environment. Everybody is struggling with this. We've had more success in certain places. It's definitely a trial and error type of situation, but it has to occur. Schools have to show that they're making some kind of accommodation, some kind of support in order to make sure that students are receiving their IEP services, even if it's within a virtual environment. This is very similar to what was in the previous Senate bill, but it's basically just saying we still need to provide these services. If we're in an independent learning environment or a distance learning environment, services still need to be provided. Where we are at now, and something for schools to keep in mind, is this issue of child find. So we have always had the opportunity as an LEA to refuse an initial assessment when no disability is suspected, and we put that denial in writing, and that's when we're looking at a prior written notice. Where the case law is, though, is that OAH tends to side with the parents and say that the LEA should consider the assessment, they should consider the initial assessment. The feeling that I'm getting from schools and what we're seeing come through is there's a lot of initial assessments. We're getting flooded with initial assessments right now. And schools are inclined, understandably, to want to push back and say, well, you haven't been in school, there's been a lapse in services, it's lack of access to education, or all of those other kinds of things, and that's why you are falling behind. While all of that may be true, it may not be defensible. And so we want to be really careful about denying assessments because the students have been involved in a distance learning environment and maybe not having a better reason to deny an assessment. The takeaway from this is that it might be a good idea to go ahead and assess and do what we can if we are receiving an initial assessment, even though this is not the best situation for a lot of us to be doing assessments, and there's some different accommodations and different approaches that need to be used. Where we're at now is that schools are required to comply with all special education timelines. We don't have that stay or hold off anymore. And where schools I know are especially feeling the crunch right now, I've experienced it with schools that I'm working with, is that all of those overdue assessments now, the clock is ticking again. So we're trying to get all the overdue assessments caught up, plus handle all of the initials and tries that are coming in and the tries that were typically due at the same time. And so trying to take care of all of this and still keep everyone safe and make sure that we're using protective equipment and things like that.
Kat, we had a question when you were talking about San Juan case about PWNs and addendums, if they documented it with those.
Can you tell me a little bit more?
Yeah, I'm not really sure what the question says. Did they document it with PWNs and addendums? And it's when you were talking about the San Juan case. So
okay.
If I have a follow-up question, I will.
Well, let me answer what I think the question was. So in the San Juan case, when they initially denied it, they did provide the PWN, they provided the documentation, but unfortunately, I'm trying to think of that. They didn't really have a good reason. The student had an IEP before and was experiencing there was reason to believe, based on the student's school performance, that the child could have been a child with a disability, but they denied the request. So it looks like their documentation, from what I could read of the case, was decent. They just, the documentation was okay, but the rationale wasn't great.
They asked they're wondering what the documentation was
A prior written notice. They formally wrote a letter and said, we're denying your request. And there had been that process in place, but unfortunately there was data to show that the student really could have been a student with a disability. And now they're in a position where they're agreeing, okay, we should assess this student, but we're trying to potentially delay it because they're saying we're not providing in-person services.
that answered.
Okay,
yeah,
good.
Thank you.
Yeah, the main takeaway from all of this is that even if your school is not providing, and I know there's districts in the area that are not providing in-person services yet, the students are not in campus, that doesn't translate to assessments. We still need to have options for assessments. Assessments need to move forward. So what was the confusion about timelines? It's understandable that everyone is confused, or that some people are confused. We've had so much new information being thrown at us on an ongoing basis. Between March 17th and July 1st, there was a waiving of many of the timelines in terms of like the 15 days to respond, the providing students with records within 5 business days if there was a due process or a resolution hearing, the right to have your former school send your child records, and there were just regular waiving of timelines under the uniform complaint procedures. So we did kind of fall into this sort of lull, or no man's land, kind of in terms of what should we be doing. We have all these cases that are piling up. We know the work's there, but we're not able to do it right now. There was a lot of confusion during this time. Well, in July that stopped, and now we have all of these overdue cases and things like that. And the current Senate bills have essentially said timelines are back on, everything's back on. We need to get all of this work done. And it's, even me saying that is overwhelming. The feeling of, the overwhelming feeling where we know we were shut down for months, and now all of a sudden, okay, we have to get all that work done. And we know that spring is traditionally a busy time for most of us, plus everything that's coming down the turn right now. So it is a very stressful time with all of the work. The current timelines are basically back in place. Initials within 60 days. We still need to do reevaluations. We still need to respond when a parent requests an assessment, all of just our regular legal guidelines. Schools have to convene IEP meetings within 30 days of parent request, and written documentation to amend or modify the child's current IEP can replace a meeting if everyone agrees. Jenna is going to talk more about it when we get into assessment practices, but from just a personal standpoint, I'm hopeful that some of this is going to result in us thinking about how to be more efficient with our assessment processes. I know some districts have been reluctant in the past to do record review triennials and things like that. In a lot of cases, though, it's appropriate. We don't need a full-blown evaluation and things like that. Like, this might provide us with an opportunity to evaluate some of the things that we're doing and looking for more efficient options. But the timelines are definitely back on. Current timelines, the CDE is continuing to accept IDA compliance complaints, but is waiving the 60-day investigation period when the school is closed during a stated emergency. The Office of Administrative Hearings is back on and remains operational. Jenna, do we have more questions?
Yes, we had somebody ask if the timeline requirement recommendation to proceed with evaluation is the same for other states, which I believe you answered.
I'm not even going to pretend to comment on other states. I'm sorry. I've only looked at California. What I can say is that the class action lawsuit included, I believe, all 50 states. Jenna, do you remember?
Yes, I believe so as well. I do, and I have another question.
Okay.
It's long, so I'm going to read it out loud. Can you clarify the difference in the finding from Parent versus Bellflower when the district documented plan for when the school and agencies resume face-to-face instruction and the recommendation to conduct parent requested evaluations? It seems not possible to conduct SLD evaluations when we cannot rule out some of the potential causes for underachievement in remote learning conditions. Could districts have a position on not conducting initial SLD requests with a plan for how to provide services as indicated by performance, as well as documentation of parent requests to follow up in a detailed plan? And we're going to talk about this later, but
yeah, Jenna's going to get into some. That's an excellent question. I know a lot of districts are grappling with it. And Jenna's going to talk a little bit about the assessment process. My hunch, I don't have a crystal ball, but I know that So the ALJs tend to, when it comes to child find, rule on the side of the parents and say, you should at least consider it. You should have at least investigated this. I have a feeling that if you push off too many initial assessments because of, lack of appropriate instruction during distance learning, it's going to end up backfiring. I've also, and I understand where the person that asked the question is coming from. Like, kids haven't been in school, obviously they're going to fall behind. I get all that. I just don't know that that's going to be an effective argument. One, there's a case that I'm consulting on now. It has not gone to due process, but it's similar to this. And the argument that I'm hearing parents say is, well, you are required to provide my child with an education. And if you're saying what you're providing now is not adequate, what's your alternative? So it's our excuse of they haven't received appropriate instruction really says we're not doing what we were supposed to be doing, and it's getting kicked back on the schools. So I think it's one that might potentially backfire. I also, the class action suit is calling into question special education services and saying if you can't provide those, you need to find someone who can. While I don't think that that would totally extend to general education, it quite possibly could. Without significant case law or guidance in this area, what I would suggest schools do if you are thinking about denying assessments is you make sure the progress monitoring data you are collecting is very, very tight. So progress monitoring every week, making sure you're documenting intervention attempts, the students' attendance, observing an intervention, and making sure that you're really, really watching what's going on with that student. And if they're not making progress, then we should be looking at initiating an assessment for that student. The other piece of this is if you want to look, I'm not aware of any other states that have done it, but North Carolina has amended their SLD guidance to incorporate the idea that we know that there were school closures and not including that lack of appropriate instruction as much in their decision making for SLD. So I do know that at least one state has started to, that they revised their guidelines to address this particular issue. Any other questions, Jenna? Or are we good?
No, I think, so we will be getting into practical guidelines for what to do for assessments during remote learning in a bit. And so please feel free to answer some of your questions about that later on if we don't answer it, but I think we'll proceed for.
All right, sounds great. So what's considered a closed school? Under Senate Bill 117, school was considered closed even if it offered independent study, distance learning, or both, which is again why we got this sort of like stay. During school closures, we can interpret closure as a break of more than 5 days. Distance learning should not be interpreted as a school closure. So this, it was kind of under 117, we could get away with it. Now it's not, it is a gray area, but there's the difference between federal laws and state interpretations of those laws. Essentially, the federal laws were never suspended. It was the state interpretation of that. So it is a gray area. It's, we have the federal laws, we have the state interpretation, which one is going to be the prevailing guidance. We have county guidelines prohibit in-person instruction and related activities when the county is on the watch list. However, that does not mean that assessments cannot occur. So we really need to think about the difference between students being allowed to go to school in group settings, cohort models, whatever, and what assessment looks like. And as Jenna mentioned, she's going to get into some of the recommendations and the things that we've been trying. I want to finish with compensatory services, and then we'll get into practical implications. We know that to the greatest extent practicable, students with disabilities need to be provided with special education and related services. The big questions are, given regression of services, how much do we need to do to think about recoupment? And have we denied a student FAPE by not providing appropriate services? Think about this and as the same way that we talk about extended school year. Has there been a significant disruption? Has there been something that's happened that is resulting in delay in catching back up? Are we seeing the significant recoupment period? If so, we might want to consider providing compensatory services. Where it's becoming problematic, and I have seen a couple of cases that are already looking at this, is that there's so much comp ed that needs to be provided. The school's trying to provide it during the school day, and the parents saying, no, I don't want it during the school day because it's interfering with their instruction that it's occurring right now. So we are looking at after school services. Even I have one district that's providing services on the weekend because the parents agreeable to it. So we're going to need to be creative and think, I hate this term, but think outside of the box a little bit to help address some of these issues. This really just raises the issue of how loss of skill will be determined. Obviously, the class action suit and what's coming from more of a legal standpoint is more assessment. I don't know that we need more assessment. I think we can probably determine it other ways, but we have to show best faith effort that we're trying. So determining comp ed, some considerations is looking at rate of growth on IEP goals, how really looking at pre-closure and current data, as well as, okay, now distance learning is back on. Are we seeing the students start to catch back up? So again, that's a similar process that we would use for ESY. There's a difference between services identified on the IEP and services offered during closure. We need to take all that into account and just make sure we're documenting that. We need to think about accessibility of services. I know most of schools are now putting into place their contingency plans and thinking about those. That should all be part of this consideration as well. Changes in the general curriculum and the level and type of instruction, and then input and information from parents needs to be considered. So these are all things that we would typically do anyway, but I think this one might potentially be what we might focus on the most, in addition to, parent input, but just thinking about, like, what did their progress look like before? What did it look like during closures? And what does it look like now? And that can help us make a determination regarding compensatory services. Compensatory services may be provided during the regular school day, and this is what I've already mentioned, but we don't want to let them disrupt the students' least restrictive environment and access to the services that they should be receiving now. The other thing that I'm seeing is some schools are trying to tack on longer service times. So maybe like an hour, hour and a half for speech, which is really too long. And the parents are pushing back and saying he can't sit for a 90-minute session. He's not even accessing the last part of that. It's not fair to him. He needs to be able to receive services, after school or at some other point in time. Special education assessments, we've talked about some of this. There's currently no waivers for initial or triennial assessments. Assessments may be conducted in person. We can also use existing data. If the district is not able to provide an in-person assessment, the district must provide parent with another alternative. And if the parent doesn't want an in-person assessment, which is fine, the district has to work with the parent to find another solution. The key here is that it needs to be mutually agreeable. We need to have options available, and that's what Jenna's going to outline. We need to inform the parent of what those options are, what the potential pros and cons are of those, and let the parent be a part of the decision-making process. So now we'll get into the actual implications and moving forward, but were there any questions, Jenna, before I turn it over to you? Okay.
No, this time.
Great.
Okay, thank you, Kat. So we are going to transition to talk about some practical implications, prefacing that, as you know, Kat and I are psychologists, and we put our heads together to think about practical implications, but we really did try to get the resources that the legal teams are putting out right now for schools. And so we're kind of combining the legal component as well as what we know about how practically we can really get things done in the schools in order to put forward these recommendations. So we'll go to the next slide. So currently there are, can we go to the next slide? Sorry, Kat is, okay. So there are currently some unique roadblocks at this time, given all of the legal cases that Kat has summarized in all of the guidelines, it is important to acknowledge that lawyers are putting forth recommendations with these unique roadblocks in mind. So they're saying that even though that we do need to follow our timelines and we do need to make sure that our assessments are valid and comprehensive, the extended closure of facilities with no access to students except via distance learning obviously imposes extreme difficulties for the IEP teams. And so with that being said, we'll talk about some of the recommendations. We'll go to the next slide. So the components of assessment still has not changed. Section 56320 requires assessing in all areas of suspected disability using a variety of tests and other assessment materials. All of this is the same. We need to look at what the law says about special education assessments and keep that consistent with what we are going to do even during remote learning. And we feel like there are ways to do that. So we'll go to the next slide. So reassessments also meet the same requirements as initial assessments, but they don't need to be identical in every aspect of assessment. And this is ed code, not just during COVID times, but in general. We tend to, or in many districts that I've seen, when we look at reassessments, we're looking at essentially all eligibility categories again, and we're trying to see the students' present levels of performance, and that could feel overwhelming in terms of what we need to do. But we need to remember that even in the ed code, there are certain areas of the reassessments that do not need to be rehashed. For instance, historical data. It's appropriate to obtain purely historical data only once in an initial assessment, and this was from a court case as well. Go to the next slide. This next slide reviews the Riot and ISIL kind of guidelines for a comprehensive assessment. So here we are remembering that for any comprehensive assessment we do, both initial and triennial or any other type of assessment we may have, we are looking at all components of instruction, curriculum, environment, and learner. And there are different ways to assess those different areas. So we're reviewing the records and reviewing what is happening at this time and in the past. We're interviewing all of the essential people that can assess those areas for the students. So usually teachers and parents and the students themselves. We're observing these different aspects of learning. And then lastly, we are testing. So one thing to emphasize in this graph is only the bottom right of testing the learner right here, performance and academic engagement. That's the only thing where we are really focusing on the direct assessment. So when we're thinking about what we can do during remote learning, we can do a lot. Look at all of these other squares. These are all still possible for with all of these roadblocks that we have right now, and they should be considered. So when we're reviewing existing assessment data on the student, again, this is just further emphasizing that a lot of what we can do right now is the same as what we could do in distance learning. So the assessments and information provided by parents, current classroom-based assessments and observations, a lot of teachers are doing one-on-one assessments with students over Zoom to collect baseline data for their own classroom. And so we can kind of get at, again, think outside of what we usually do with our typical academic achievement testing, and really value some of the classroom-based assessments that the teachers already naturally give, which I think we could do better at in general, even when we are in person. We'll talk more about observations later because there's obviously some observations are looking very different right now. But in terms of the additional data that we need to remember we want to gather information about whether the student continues to have a disability. That is what we are doing with a special education assessment. Additionally, their present levels of performance and their educational needs. So we're always thinking about those three things when we're informing an IEP. We are going to talk about 4 different assessment options, well, essentially 3. So there are records reviews, there are remote testing, there's in-person testing, and in-home testing, which in some is not recommended by the legal team or by us with our clinical judgment. So we're going to go into each of these and give you hopefully some helpful information. So the first one, records review, I just want to point out that there are different terms that people use for records review. And if you look across states too, some states have official names for what a record review is. When we are talking about record review, we are looking at a review of the existing data, and we're not doing direct testing, meaning we're not doing cognitive testing. We are not doing any sort of direct academic testing. And depending on the district that you are in, sometimes a records review may include gathering new information, such as behavioral and emotional symptom checklists, or even conducting observations. But we are really talking about a record review where no data is collected and no direct testing is conducted. So this is based on kind of the recommendation that an assessment plan is sent out if you're collecting any new information. Records review, we're purely looking at background information. So we'll go to.
Sorry, do you want to expand a little bit about how we're thinking about in collecting teacher input, even though they've had limited experience with the students?
Yes, I think we'll get into it more specifically, but in terms of the record review, we are looking at background data. So when we're talking about the records review specifically, we're looking at past teacher comments, and we can look at, past teacher feedback, either from past reports or from report cards. When we're looking at the assessment option that we are collecting current data, we are getting both last year's teacher data as well as this year's teacher data. But I'm going to hold off on that because I want to talk about the difference between rating scales and how we're just talking with teachers. We'll talk about that in a little bit. Okay, so for records reviews, we're reviewing the existing assessment data on the students, including their assessments and information provided by the parents, current classroom-based assessments and observations, and teachers and related service providers observations. So again, this is the same information that we put in the earlier slide, where we're looking the essential components for any assessment that we're doing. We're still needing information about whether the student continues to have a disability, their present levels of performance, and their educational needs. So when do you decide to do a records review? So this is where we really took some information from legal guidance, because records reviews are less legally defensible. You're not getting as much current information, and the point of a reassessment is to look and see if there's continuing eligibility and continuing needs. And so it really should be a careful process of when you're deciding not to collect new current data. If you're thinking about cases that might typically be a records review, you might be thinking about students who are quite lower functioning, who maybe are in a middle school, high school, they've been receiving special education since preschool, and they're in a functional academics class. We hope they're making progress, but we're not really concerned about their eligibility changing. So we're thinking about a student with ID, a student with severe autism. And so in that aspect, that may feel like an appropriate student to look at a records review rather than a comprehensive assessment. But what we need to remember is we're not only informing eligibility, we're also looking for present levels of performance. So if you feel like you can do that with other data, so whether it be classroom data, parent report, then that may be more appropriate. It's definitely not appropriate for initials. I have heard of districts doing initials that are essentially records reviews if there was a private assessment. That's not recommended, because I think we get in a really tricky situation there where it is our responsibility as a school to do our own assessment to look for special education eligibility, whereas private assessments are usually not looking at that. It's also kind of safe to think about maybe you're looking at your second triennial or more when you're looking at a records review. And of course, if you have a student who has been in special education for a long time, but there have been significant changes in the student's circumstances, either personal or their grades plummeted in the past 3 years, then it would not be appropriate to do a records review as well. And then the lawyers are just emphasizing this is less legally defensible. When we are doing a records review, there are different ways that lawyers are advising us to handle the consent and notice process, as well as what school districts are doing. So the best practices, steps that we have put forth and recommended is to first discuss this with a parent or guardian beforehand. Already the assessment and reassessment process can be quite confusing for parents and caregivers. So you want to remind them what the student is due for, if it's an upcoming try, and what the purpose of that try is. So again, reminding them that we are looking at continuing eligibility, and we are looking to see their present levels to inform their IEP services and supports. And so then you should have already done a partial records review to kind of help them understand where you are coming from, and help them see that you have the data that you feel will already be able to inform that those services and supports in their IEP without doing current formal assessment. So it is recommended that written parent or guardian consent is received before proceeding with a records review. So some lawyers say no assessment plan or report is needed if it's a pure record review, but we recommend that the best practice is to use either an assessment plan to signify a records review. There are some or a prior written notice. There are also some worksheets. I know at least SACE, for those of you who use SACE, there's a triennial worksheet where you submit it to the parents, where it gives a breakdown of why you want to do a records review and has them sign it. I don't want to get into all the specifics because we all use different systems, but that being said, it is important to get some sort of written consent after talking with the parent or caregiver. And then you can always talk to the parent about this, and then you should know for your own practice, if it's later determined that more information is needed, the district must recommend an offer assessment. Okay. So, the next assessment option is remote assessment. So remote assessment is what we are thinking about when students are in pure distance learning right now, and when in-person assessment is not recommended either by the county health guidelines or not permitted by the district. So in terms of remote options, you probably have heard of Presence Learning by now. They're definitely, this is their prime time in their company. Presence Learning is an organization that is conducting assessments in a remote way, but they do require on-site proctoring. So they have professional facilitators, and then I've also heard of different school districts using school staff as facilitators, which gets into the question of then why you wouldn't just do in-person assessment. But that just because that is a well-known organization, I put it there as a remote option. We as Psych Services, we're conducting remote assessments using measures validated for remote use without a facilitator. So when we were tasked in the summer to come up with a plan of how to continue valid comprehensive assessments during distance learning, we researched all of the best practices in ways that we can implement measures that can just be done with a computer that were validated in that way. So I know some people are, or some school districts may be doing remote, Zoom testing of using the WJ or using other assessments like that. We wanted to stay away from that at this time because we really want to think about the standardization process and adhere to it as best possible. So we have found some measures for virtual computer-based administration. And when you receive the slides and the recording after our presentation. We'll also be sending our assessment guide of the different options that we are currently using at Psych Services, and the services that we have available right now if you want to collaborate with us. So of course there are risks. Oh, sorry, we'll go back for a sec. There are risks for remote assessment. There are not many validated measures for virtual computer-based observation. We wish there were more. And then of course we run into some issues like in California, we cannot do cognitive assessments with African-American students and have something like a full-scale IQ score. So we run into those kinds of barriers. Lawyers say that full remote assessments will likely be dependent on the credibility of the witness. So if it is taken to due process or taken to court, it will probably come down to the district psychologist versus the expert the parent hires. This is a new territory. There's never been a time where districts and psychologists are pushing for remote assessment. So as Kat shared some of the legal cases that have happened so far, in terms of with remote assessment, we don't know too much, but what we will be kind of emphasizing is how you can protect most of your data when you are sharing it in a report. It is important that you document what is being recommended for conducting reassessment and why it cannot be administered remotely. So a good example right now, for instance, is the ADOS-2. The publishers and the creator has said do not do the ADOS-2 during this time, either remote or in person because of the PPE. And so that is something that you would write in your report about why that couldn't be done and then what you were doing instead. Okay, so our next slide is about in-person assessment. So in terms of the guidelines for when you would do in-person assessment, this is something that it seems like most districts are following their county guidelines, which is also what we would recommend, to follow the written health and safety guidelines of the County Department of Public Health, not only for your safety, but also because that is defensible as well. In most of the legal guidance that I have read or participated in webinars, most of the lawyers are really emphasizing we should be doing in-person testing. We got this feedback even when the counties were, in the red, the highest tier zone. So of course there's obvious health risks, and we'll discuss safety precautions later. Tests will likely be outside standardization. There's kind of no going around that. And so those are our risks when we're doing in-person testing. We'll go to the next slide. In terms of consent, this also hasn't changed. So districts must take documented reasonable effort to obtain parental consent. If parents fail to respond, the district can proceed with reassessment without parental consent. These are ed code guidelines from, even when we are not during COVID times. However, it's a bit more complicated to do reassessment without the parental consent because you need the parent to bring the student to the school, or you need the parents involved much more in the process of scheduling since the students aren't there for you to take out of class. So if the parents do refuse consent to the assessment plan, and we'll talk about different reasons why they do that, but if they're just not consenting to reassessment in general, the district may, but is not required to pursue reassessment by showing at due process that it needs to reassess student. The district does not violate child find reassessment obligations or its obligations to determine eligibility if it declines to pursue assessment through due process, and that's from ed code as well. If the parents are declining because of safety reasons, we'll talk about that next or in a bit. So in terms of assessment options, in-home, the answer is no, do not do it. The liability is huge. And this is from the lawyers as well, kind of giving the guidelines of assessment should not be conducted in the home environment. Also, no aids or any types of special education services should be conducted in the home. Not only with liability, but I think this also sets up precedents for when we do go back to in-person, if a student is responding really well with in-home support, you're kind of putting yourself in a spot where that could be easily argued that that's something that the student needs long-term. Okay, so in terms of liability and consent, on the next slide.
Jenna, sorry, I just
Sure.
want to we've had a couple questions show up in the chat that I think are
Okay.
relevant to the entire group. Somebody just asked a question about FBAs and BIPs, which is
Mhm.
a great question.
Yes.
I've done a couple FBAs so far in home, or not in home, but through in-home FBAs, remote FBAs. The question where it's coming up, and some of this is related to compensatory services and making sure that the student is still receiving FAPE, is the districts are looking and saying one of the reasons that the student is not able to access distance learning is because of behaviors that are in place. And so as part of the FBA process, I'm logging into Zoom, watching the students during instruction, talking to related service providers and things like that, and looking at, is there anything we can do to help increase the likelihood that the student is able to access instruction? Districts are also starting to partner with agencies that can provide in-home behavior support services, which that's not something that a lot of districts are set up to do right now, but the BIP would include suggestions for that if that was an option, or if the parent is, some of the students are already receiving in-home ABA through their insurance, and those agencies have picked back up. So the if the student had an existing FBA and the FBA was to address problems that were occurring within the school, obviously that's not a good time, that's not relevant for us to provide that now. But if the student is having difficulty accessing distance learning right now due to behavior, that is something we should consider. It's not an easy answer to solve, and it's probably going to open up a bigger can of worms, honestly, because it's like, okay, now we know these behaviors are occurring. How are we going to support those? But that's where these issues of comp ed and denial of FAPE and things like that are starting to emerge. So and there was one more, Jenna, the attempts. Jenna, do you want to answer how many attempts to reach the parent is required before testing the child when the parent fails to respond?
Yeah, I mean, this is not something where, law says or ed code says that you must try 3 times, you must try 4 times. The best recommendation is to make sure that when you are reaching out, it's documented. So trying, through calling, but also emailing, mailing. I would recommend after a phone call and after an email that you send a hard copy with a return envelope. Right now, at the school district that I work at, it's really hard to get assessment plans back because students are not going back and forth. You can't put it in their backpack. And so make sure that it's not an access issue. Make sure you are providing them with tools to return the assessment plan back to you and ask questions if needed. But document is the best guide. Okay, so in terms of liability and consent, so schools cannot have parents waive liability if students contract COVID after assessment. It's not applicable for essential activities, and I think some school districts have, or you should have, some sort of consent form where you are talking about the risks and you are talking about what are the potential risks if you are doing in-person testing. Parents and guardians should be notified that we cannot guarantee 100% safety. That's just not possible. So you do want to give options other than in-person testing. So whether that be hold off on testing until we're back in person, and if that's the case, I'd recommend doing a records review or something now. You do need to hold an IEP meeting still, but then you still need to offer testing when it is safe or when parents feel like it is safe. You could gather as much information as you can through parent rating scales, through Zoom observations, things like that. But we want to make sure that they are given the options to do what they can now, what they feel safe with, and then hold off for anything they want to at a later time. Excuse me, parents and guardians, they can sue if COVID is contracted. Evaluators, not the districts, are protected by California state law. So I'm thinking there's a lot of school psychologists here. I'm not sure. But in terms of from the position of a school psychologist, lawyers say you probably do not need personal liability insurance because most of it falls back on the district. And so although some lawyers have advised like personal liability insurance is never a bad idea, but it doesn't seem necessary at that time. Let's see. Yeah, I think that was all with that slide. Okay, so in terms of health and safety guidelines, as I mentioned before, so state guidelines can be unclear or non-existent. It is getting better, a bit better now, but especially at the start of the school year, it felt like there were not clear guidelines. But it is always safer to refer back to the County Department of Public Health. I know lots of special education departments and schools are consulting directly with the county, and the county sometimes is giving direct guidelines for testing. In terms of who can administer the safety measures, anybody can take temperatures with the touchless thermometers, but disinfection does require training. So this is something that is prevalent even outside of COVID times. I know to use Clorox wipes, I think you need to go through a training for some districts. And so it is important to make sure that your district is set up with the correct trainings to properly disinfect, especially during this time. We'll go to the next slide. So the essential safety protocols are highlighted here. If possible, you want to keep assessment locations to 2 to 3 rooms that are thoroughly cleaned after each use. Of course, you want to consider how many people are assessing, and it could be safer, for instance, if you're at a high school and there are a lot of special education teachers testing as well as psychologists, maybe you want to keep that assessor within their own room and just make sure it's cleaned thoroughly. There's also considerations, again, consult your county, but the county guidelines of health, I know sometimes say you need to wait like an hour between each student or a half hour between each student. It really varies. Outdoor assessment is ideal when possible. That's going to be a little tougher right now as we're going into winter. And then again, just do not do in-home assessments. Okay, so in terms of test validity, changing protocols and practices should be noted in document, but it should not inhibit assessment. So what this is really emphasizing is actually whenever we are doing testing, it's very, very rare that we are 100% lined up with the standardization of the, with the conditions that the examinees were standardized on. So just because we cannot perfectly match the administration guides of different assessments, it doesn't mean we shouldn't do that assessment. There are definitely times where it is more important. For instance, we had a hard time thinking about auditory processing assessment because it requires a lot of examiner verbal output, and then that is a lot harder when you have a mask. And so that is an area where we would think about how that is directly impacting the outcome, the data. So the validity and reliability of data is always an issue. The environment's never perfect, but we want to be overt about the limitations of the test. So if it's something like a TAPS or a CTOP and you are using a mask during administration, you definitely want to have a clear discussion in your results section about how you think the test results are being impacted. The more that's attempted and the more that's documented is better. It could require a lot more assessment than you typically do. Maybe you're doing several auditory processing, maybe you're doing some where there's a computer recording, which would be more recommended over the examiner giving output. And so it's just important to keep in mind that okay data is better than no data at this time. So I thought about, and I am sure maybe you guys too have attended different seminars and webinars on doing assessments during COVID, both from lawyers and from a clinical standpoint. And I've seen a lot of statements for reports that are kind of catch-alls of, this protective gear was used, it could affect the outcome, etc. it's really important that your statements for replacing typical assessment measures or for going outside standardization is personalized to that report, is individualized. That will be most defensible. What we are getting, the legal guidance that we're receiving is it's not the best practice to put a paragraph at the beginning of the report saying, this is what was done differently, please interpret with caution. You really want to parse apart the different assessment portions of your test and describe how each of those areas were impacted. So whether it be the rapport that was made, or whether it be the exact administration of the test, there are different things that we want to consider. I think that's in the next slide. So in terms of statements for the impact of safety protocols and protective gear, here are different questions to think about. All of these different components can impact the outcome, or they may have a minimal impact. And again, we're not going to put a general statement here. You just have to think about, for your individual testing session, what were the different components that may have influenced the results. So for all assessment options, it is important to use a variety of services, to go to the publisher and manual for information rather than the salespeople. We have really researched, the big publishers and organizations and their guidelines for assessment. The best way to kind of look and see what is most valid is look at the research and analysis conducted. The more defensible you can be about the test that you select, the better. So if you're using a cognitive assessment that has not been normed at all for remote testing versus a cognitive assessment that at least has some equivalent studies of when it was administered remotely versus in person, then that's better. Of course, a standardization sample when you're looking at remote testing is the best, but that is really few and far between. So you want to explore and document all your options and really show the effort in regard to validity and reliability. So so the next slide is a statement for conducting assessments outside of standardization. So just more questions to think about. Was the seating arrangement different than what is proposed in the manual? Even things like, was a student report form administered through interview on Zoom instead of a physical rating scale? You want to think about all these things, and really there's just not, as we'll go on the next slide, if you want to move to that one, it's just document, document, document. We want to document everything, how the assessments were selected, how it was different, the changes in administration with respect to standardization, the impact on results with PPE and social distancing. And again, document each report individually and avoid those general statements. If the district or SELPA does not let you test, and I'm speaking to, I guess, the psychologist population, there's nothing you can do as a psychologist. It does fall on the district. The most you can do is do a record review and follow up with in-person testing when allowed. And I'm looking, I see a comment about assessments validated for remote assessment without a proctor. We, like I said, we're going to be providing you with our handout that we give to districts or other school psychologists who are looking to contract our services. We're using a computer-based cognitive assessment called Measure that has been validated for use of computer administration. There are the RIAS-2 also has some evidence of equivalent studies. And so again, there's not a lot out there right now, but we're trying our best in our company to maintain the clinical integrity of what we're doing by really looking to see at those measures that have been validated as much as possible for remote. In terms of observations, it is a critical part of all assessment. So this is another thing that I feel like even outside of COVID, observations, sometimes legal cases fall on observations. It's important to observe in a setting that's relevant to the diagnosis, or the eligibility category. So I think that there have been reports that have gone to due process or have gone to courts where if there's not an observation in a social setting and autism is one of the eligibilities, then that is not good for the district, not good for the school psych. We really need to look at the setting in which a child is most impacted, and then best practices too would be to look at a setting where the child's less impacted so you can compare their behavioral observations. It is mandated by law when assessing specific learning disability. That is the only place in the Ed Code where it's specific to an eligibility, but really I can't fathom doing an autism or ED evaluation without some sort of observation. So we recommend an observation for any assessment you're doing. So how do you do those observations? We'll go to the next slide. Of course, there is, most students are in virtual classrooms at this time. So it's not ideal, but it is an instructional setting and it is completely defensible. Can be creative. So especially with older students, a lot of their cameras are off. You can live stream a work session. You could ask parents for assistance with that, where you are recording them doing their Zoom class. So you can see the student's behavior from the outside. You can, for a younger student, maybe if you're doing an autism diagnosis or such, if it is cleared by your district, you can meet at a park or outside for a play observation. You could ask for a video recording of interaction with a sibling. You may need adapted consent form or procedures, but you just need to be creative and see any sort of data that you could get is good data. You just need some observation. So in terms of teacher data, there are, a lot of what we do is sometimes dependent or at least we're largely looking at rating scales. So there are challenges for using both new teachers and old teachers. If you look at the guidelines for administering specific rating scales, it's asking teachers, you need to know the student for at least 6 weeks or for at least a set amount of time. And there has been some legal guidance that if this teacher does not know the student, in a typical capacity, then to not do a rating scale like that. So to not administer a BASC if they're only doing distance learning. Additionally, if last year's teacher saw the student last February for the last time, that also wouldn't be a valid representation of their current functioning, especially if you're looking at something like OHI or ED. We are tending to rely more on qualitative data from new teachers or qualitative data from old teachers. Even though we like our rating scales and we like our numbers, there's also a lot of legal guidance that rating scales, you can poke a lot of holes in them. And so if you are looking at your eligibility criteria and making sure that you're interviewing teachers, parents, old and new teachers about those different areas, then that could be just as legally defensible as rating scales. For eligibility, you can of course review eligibility when school reopens if necessary. So if you feel like further testing is needed or there's observations in the classroom that you need to conduct that are imperative, then that's always something you could discuss at the IEP meeting. We talked a bit about lack of appropriate instruction. The reality is their general education instruction right now for many students is through remote learning. And so that's something that we need to look at. We need to see if they're accessing all of the resources available to them during remote learning. For instance, at the high school I'm at, a lot of students are not utilizing their office hours, but office hours are a general education function. So we need to make sure that students are utilizing what they can at this time before we're considering, an educational impact or lack of instruction. And then focusing on pre-COVID data is important, especially when we're looking at, for any of the eligibility categories. Distance learning shouldn't be the sole determining factor. We need to think about how they were doing with in-person instruction as well. So learning loss may become an issue, but we need to focus on the disability, not learning loss during the pandemic. And this is a really important statement. Remember, special education is about a disability. If a student is not performing well or not accessing, not attending school or not attending their Zoom classes, is that because of a disability or is that an environmental or some other factor? So the processing and cognitive tests are what really tease out the true disability. So a brief statement on some eligibilities. PSW for specific learning disability is maybe hard to defend at this time, and lawyers are advising against using it right now. They're even encouraging to try other eligibility categories when needed, and you can consider Part C if you don't have, that standardized IQ score and academic achievement scores. OHI can really be a catch-all, but other categories should be explored first. But if we're thinking about ADHD, anxiety, and depression, OHI, especially right now, may be safer to look at than ED because we can't really look at that some of the peer impact and their relationships with teachers. That's skewed right now. But again, you should remember that they need to have anxiety, depression, and need special education. The disability does not equal eligibility. So finally, just remember, no exiting without an assessment. Record reviews, not sufficient to exit. Think about what you would do maybe at an annual meeting. So in terms of, maybe you could change a small service at an annual meeting, like if you even, in terms of their SAI, like what subject they need that in. But if it's not something you would do at a annual IEP meeting, that it's definitely not something you should do without reassessment.
Jenna, we have two questions that just came in that I think are appropriate for the group. The first is reminding everyone what Part C refers to. And the second is a question, and I'll give my 2 cents and then you can follow up, is in looking at kind of considering lack of appropriate instruction or what they should be having, should schools have guidelines in place, like you have to attend X number of sessions, you have to provide work samples or access office hours and things like that. In regard to that question, I would advise schools to be really careful because we start getting into issues related to equity. Not all students have access to the same level of internet. There's issues related to daycare and how much support they're getting at home and things like that. So I understand the desire to want to put those procedures in place and be careful about that, but we really want to be careful when we're putting up potential roadblocks for eligibility that are outside of the control of the school. So they're things that could disproportionately negatively impact certain students.
Mm-hmm. Yeah, that's a great point. In terms of Part C, I think I shouldn't have used that specific term, but I'm talking about with specific learning disability, we have different ways to qualify. And one of those ways to qualify is looking at alternate means of assessment. So that's giving you permission to qualify a student for SLD with looking at curriculum-based measures. So it could be student data from the classroom. It could be looking at their progress, like the progress monitoring data that teachers use throughout. And so it kind of excuses you from using those specific standardized scores and instead looking at other measures. Is this you, Kat?
Okay, so the last thing, and I apologize, everyone. Somehow I got my video turned off and I can't get it back on right now. So I am here, but counseling services, we wanted to address this briefly because this is an issue that is potentially going to come up, is that oftentimes we were considering offering counseling services because the student's not responding to the tier 2 services that we have in place or all of the other things that are going on. Counseling services can be provided remotely. I mean, I think we know that, we've been doing that, but where it might come up is students that need new counseling services. And so we want to think about those students as well. But some kind of procedural things is HIPAA doesn't apply for school therapy. even if an LEP is acting as a school psych, they're not bound under ed code for HIPAA. FERPA is more applicable. So especially when I think about group counseling and confidentiality. I know personally, some of the things that I'm running into is we can't guarantee that other family members and things like that might not be able to see members of the group. And so I have moved to students that were receiving groups to individual just to help ensure confidentiality. We want to be conscious of issues of mandated reporting and confidentiality, especially the location of the student during services. For example, if we are suspecting abuse and we report it, we want to be thinking about the fact that the child is in the home the entire time, and we are not necessarily able to help keep them safe by having them stay at school until authorities or somebody can come into play. So we really want to just think about some of the consequences associated with the decisions that we're making, and making sure that we're giving notice to parents about privacy issues and being transparent in what we can ensure and what we can't. And like I said, we may be looking at moving to more individual services or different types of groups and things like that during this time, just so that we can help ensure confidentiality to the greatest extent possible. And then when it comes to ERMs and the CDE recommendations, given that the pandemic is resulting in additional stress, teams are strongly advised to consider informally or formally assessing for additional mental health needs and considering new mental health concerns as potential areas of need. I know most of us are not necessarily looking for extra work at this point in time, and it might seem like an additional hassle, but we do want to think about the fact that some of our students who may not have had mental health needs in the past now are experiencing additional stress, and we might want to be thinking about adding those services on. I've had a handful of cases in recent weeks where we're adding counseling services on, and it's not a student who was ever suspected of that in the past, but we are now concerned about that because the current stressors that are occurring. So the bottom line is we don't want to explain away possible mental health concerns and just say, oh, it's a result of the pandemic. We don't necessarily have an end in sight for this, and we're looking at potentially the rest of the year in a distance learning environment or hybrid environment. It's no longer kind of a transient situation that we can just say it's going to get better in a couple of weeks, unfortunately. And so we need to look at this as potentially needing a service, that there might be some legitimate concerns that are requiring that. So we'll go ahead and open it up to questions. I'm going to stop sharing just so that I can turn my camera back on. I know we have some that are coming up in the chat. Any questions that you might have, feel free to put those in there, and we'll we're just reading through. I'll address RTI, and Jenna, feel free to jump in if you want to. I have used an absolute low achievement model, or RTI, for eligibility for years now, where we're looking at Part C or RTI. A common misconception of RTI is that there has to be this really formal intervention process. There doesn't need to be that. We're looking at, does the student have absolute low achievement? Do they have a need that we need to address? As well as, are they not making adequate progress? Are we not seeing progress even though they're receiving instruction? One of the things, I realize this is pretty unprecedented, but one of the things that you might want to keep in mind is, how is the rest of the class doing? So with RTI for eligibility or an absolute low achievement model, oftentimes we use local norming, because we can compare a student to their peers that are very similar to them. And so, is the rest of the class showing progress? Is this student, despite receiving instruction or intervention, and you can do intervention remotely, what are they doing? Are the other students making progress? Are we seeing a student that is still having difficulty? You also want to think about, were they struggling beforehand? Do we have SST data? Do we have intervention data that show that they were struggling prior to that? So you can think about using that kind of absolute low achievement model in that sort of setting, but you could include that in with the Part C recommendations.
Do you have a survey survey that you could put in the?
Yeah, I will put the survey in right now. So we're putting the survey into the chat box. Let me make sure I'm sending it to everyone.
I just saw one, the last question popped up. Did the publisher state that ADOS 2 cannot be administered? Yes, the ADOS 2 is not recommended at this time. So we recommend rating scales, and then UCLA has also developed an alternative autism measure to use your ADOS materials through distance learning. So that's something you could look into.
So Amanda asked the question, and I know we've had a couple of questions, like how are districts going to handle a flurry of initials? I don't know how, I mean, every district's going to be individual or have to handle this differently, but essentially we can't delay. So if that means, you know, pulling people from other positions or kind of the clear indication that is if you have to hire or bring in, you know, substitute psychs or outside support in order to get these done in time, that needs to happen. We can't delay them due to COVID anymore. And there was another part to your question. I mean, yes, best practice is to say we don't want to identify student as a student with disability if it's just due to lack of appropriate instruction. But that was in the time when we could ensure they were getting access to instruction. So they're in the classroom, you know, we can handle behavioral needs, we can make sure that they're getting evidence-based instruction. If they're not attending office hours and things like that, really best practices at this point is to try and work with them to provide asynchronous learning opportunities, figure out why they're not accessing. Is it lack of technology? Is it lack of supervision, to try and support them in that? I get it's a rock and a hard place kind of situation right now. And you can definitely say, yes, they'd be making more progress if they were attending virtual services. And we want to make that part of our decision making. We're just not sure how defensible that's going to be at the end of the day, unfortunately. I've seen a couple comments about your schools aren't providing intervention, but they want special education services. That is a whole other ball of wax. Let me see if I can try this again. Copy.
The link, yeah. So Kat is placing the link again in the chat. So please complete that before leaving. It helps us with our feedback, and let us know if it's not working.
So Rachel, when you're saying that you don't know how to fight that, was this a problem that was present before COVID hit? Is it just a lack of intervention in general? Yeah. You know, from someone who's had to help districts tackle this in the past, I think speaking to the monetary aspect of it is helpful. If you talk about the amount of money it costs to provide special education and do psychoed assessments and all of those kinds of things, it's actually cheaper to provide pre-referral intervention. One of the things that might be stopping your district, I don't know what district you're in, is that people think intervention has to be really hard, that it's, you know, we have to have these interventions that cost a lot of money and you know, or just, it seems like a very onerous type of situation to be in. It doesn't have to be. It could be intervention that's provided in small groups in the classroom. There are materials actually that are evidence-based that are free. If you're at are you at the elementary, Rachel, level? Public, yeah, that's fine. Independent charter K-8. Look at I'll type it into the chat box. Yeah, the second link was the same as the first link. No, I'm not talking about Dibbles. Dibbles is a progress monitoring tool. It's not an intervention tool. I just typed in the Florida Center for Reading Research. Obviously, there's lots of intervention materials that are available. The FCRR materials are completely free. You do have to have access to a printer so that you can print them off. They are, they're research-based. They're really good materials for targeting reading interventions. You do want to progress monitor with those. You can use Dibbles or AimsWeb or FAST. Dibbles does still have a free component, although it takes a lot more work on the back end because you have to graph the data yourself and chart it, but it is still a free option. If you are in a district that's like, we don't have any money for interventions, we don't have any money for these things, check out Florida Center for Reading Research. I've used these in districts all over Southern California, and they're not, I mean, it's not going to solve all your problems. You still have to actually do it, but those are evidence-based interventions that you can use. They're mapped out nicely. There's videos that show how to implement some of it. So I don't understand teachers, Dawn. Is that a typo?
Someone asked about group counseling and if we should switch everyone to individual counseling because of the confidentiality issue. Group counseling confidentiality is never guaranteed with group counseling. And although it brings in, they're in a home setting, so other parents could potentially see the other students involved. If you have appropriate consent form, it's still okay to do group counseling.
Yeah, thanks for that clarification, Jenna. When we're talking about confidentiality, it's more other people that might be in the home that I've had some parents raise some questions about, not necessarily other students that are in group, because obviously if we were in school, those students would also be they would know that they were in the same group. Yeah, I mean, Rachel, some of your issues related to teachers don't want to do tier 2 interventions and things like that. That's a bigger issue for you to handle, with administration and kind of one of the ways I've seen schools change rapidly is when administration just pushes back and says, unless you are showing proof that you've done an intervention and you're trying this, we're not taking your referral. We don't want to be so punitive, but sometimes that's what it takes in order to get schools to start to shift and take ownership of their students. The other thing is that if we do take sort of that like top-down approach, we want to make sure that we're providing a lot of support to teachers so that because some of this comes from a fear. I don't know what to do. I don't know how to implement intervention. I'm not sure what I'm going to do with the rest of my students, all of those kinds of things. So we want to make sure that we're supporting them in that as well. Okay.
I think we got all of the questions.
Yeah.
If we missed, please let us know. But thank you for all of your involvement and your engagement in our session.
Yeah.
So happy school psychology to all of you.
Thanks, everyone. So yeah, we'll stay on, but you guys can go ahead and log off as soon as you fill out the survey. If you need a certificate, that can be sent to you, and you'll receive a copy of the presentation and the recording.
Issues with the survey, I'm not sure.
Sydney, I think I'm just going to put Amy, I'm going to stop recording. We don't need all